The mandate of the Competition Authority of Kenya, and as we refer to it, competition, CAK, it's to regulate competition in the economy. And how does Competition Authority of Kenya regulate this competition? It's through control of market structure. Number 2, control of market conduct. Number 3, ensuring that the government regulations and the promulgations which it makes are supportive of the market environment. Number 4, it also ensures that consumers are protected from what I may call unfair trade practices by the suppliers of goods and services in the market. And there's another added draw which came about 2-3 years ago, that is control of abuse of buyer power.
Buyer power is the power that a market player could have, usually a buyer, by virtue of either their dominance in the market, in which case they're able to enjoy a monopolistic position, or by virtue of having market power. They may not be a monopoly, but they may actually have market power which they can use as against their suppliers. Abuse of buyer power manifests in market conduct that would not arise if the market was properly competitive. And an example would be pushing of risk to suppliers. I'll give you the example of pilferage or loss of goods that have already been supplied and delivered to a buyer, and you have incidences where there is loss, either even, for example, expiry, and that burden, instead of being borne by the buyer who already has accepted delivery, is pushed back and charged on the supplier. Remedies available for abuse of buyer power are the same ones available for anti-competitive conduct under the Competition Act. There is a criminal sanction under Section 24, subsection 3 of the Act, and this could be 5 years imprisonment or a 10 million shillings fine, or both. Okay? There are also administrative penalties, and these are available under Section 36, and the Competition Authority can impose them as an alternative. And there are a number of them, but the most critical is that the Competition Authority is able to impose a penalty, an administrative penalty of up to 10% of the net annual turnover of the offending firm for the previous year.
Many sectors in Kenya are regulated. But in addition to that, there are a lot of sectors where there is an aspect of duplication in terms of mandate with the authority. And even where there is no duplication of mandate, there are sectors where we have a lot of interest as an authority in. Just to give you a background, some of the matters the sector regulators work closely with involve, for instance, the Communications Authority of Kenya. We work very closely with the Central Bank of Kenya. We work very closely with the Agricultural and Food Authority. We work very closely with the Energy Regulatory Authority and many other sector regulators. So how we work with them is that because we have areas where there is duplication of mandate, we realized that it was very important that we had a proper framework of how to handle issues to avoid one forum shopping where you have, for instance, a complaint going to Central Bank or Communications Authority of Kenya, at the same time it's been lodged with ourselves. Because we are using public resources, it's good that we are prudent in how we use public resources. So we've come up with a memorandum of understanding. And the purpose of this memorandum is basically to streamline how we handle our respective mandate areas. They do not, host any agency's mandate, but the purpose is we've created in all the frameworks we've agreed on. We've created frameworks through which, and committees with many agencies that sector regulators that we work with. And the purpose of these committees is to see, complaints when they are received and agree on which agency is the most, effective in handling.
When we talk about control of market structure, what are we talking about? Is that all the mergers and acquisitions in the country, they have to be approved after analysis and determinations made by the Competition Authority of Kenya. The essence is to ensure that we don't create private monopolies in a liberalized market. In terms of regulating market conduct, we are talking about when two competitors come and agree on the terms and conditions of competition, that they will not be competing independently, that they extinguish the purpose of price signaling in the market in terms of setting the prices in the market, and they allocate themselves territories, they allocate prices, they fix prices, the authority will come in and break this kind of arrangement. These are what we call cartels.
The authority, based on the Act, is supposed to approve all mergers that happen in the economy. But because to reduce the regulatory burden of that provision, we have come up with a two-pronged process. One is an elaborate process where a merger, of meeting a threshold of at least 1 billion Kenya shillings. Once they have been notified to us, they go through an elaborate process that involves board approval, which takes slightly longer, roughly 30 days. However, with regard to mergers that have no serious impact or that are benign to competition, we have a fast-track process where we actually exclude them from the provisions of the Act. And this normally happens within 14 days maximum, but within even a shorter period, depending on the type of transaction.
And also when it comes now to consumer protection, there are 4 key areas we focus on. One is misleading advertisement. Number 2, it's misrepresentation. Number 3, it's also what we call unconscionable conduct. When you go to a bank, you need a facility. You are given a document which is about 3, 4, 5 pages with very small print down there. And then when you sign it, you have been told that the interest rate is about 5%. After that, you start seeing interest rate changing and all that, what I may call dripping charges. You didn't have the capacity to comprehend all those 5 pages because even the language it had been written, it's a language you couldn't comprehend. That is what we call unconscionable conduct. I also talked about advising the government, ensuring that the rules and regulations the government promulgate are supportive of competition in the market. We have been having a situation, and I'm not casting aspersions, where laws which are promulgated are hindering entry into the market. Some county governments may decide that it's only one person who will be buying some certain products from a certain county, thinking that they are helping their own in their counties, and yet they are reducing competition. Also, we may have other promulgations like the ones where people are supposed to pay cess across counties. It's not adding value, but it's increasing the cost of doing business, barring SMEs from entering the market, and therefore reducing competition.
We have launched a case management system. We realize that automation is a global trend, and as an authority, we could not be left behind. We have the additional advantage that with regard to the case management system that we have launched, we have involved our stakeholders throughout the development of the system until its launch. It's now operational. Some of the things we expect to benefit our stakeholders from the launch, of course, is an improvement in the turnaround times. In terms of our decision, as much as we're taking 30 days, we expect that going forward, that period could even be reduced further because we realize these are business people. They want our approvals to we shouldn't be an impediment to investment. So that is one of the things that the CMS system will enable us. The other is with regard to previously, and basically like our merger analysis process requires a lot of bulky documents. Now the system has enabled stakeholders to lodge their documents on the system. That significantly reduces, of course, on their part, the costs associated with lodging a merger, because now they're able to lodge online the mergers that they have been lodging previously using manual documents, which are very bulky. The other issue that we're seeing is with regard to communication. You realize that when you're doing a merger process or even a consumer complaint or even when you're looking at enforcement, some of the matters we do around enforcement, constant communication with stakeholders is very important, and it has a bearing on the timelines within which matters are concluded. So going forward, we think we are now in a better position to serve our stakeholders, and deliver decisions even more quickly than we've currently been trying to do.
Let's look at the impact of the decisions we have undertaken as an agency. One, it's opening up markets for specialty tea in the country, where to plant purple tea or green tea in Kenya, you required a letter of no objection from the incumbents. And I don't see any competitor who just say, you come and we compete. Obviously there were some objections, and as a rational competitor, you wouldn't want to encourage competitors. But we engaged the Ministry of Agriculture through the Agriculture Food Authority, and they removed some provisions which were barring the growth of specialty tea in Kenya. And we saw some entry of 4 factories with direct employment of 250 Kenyans who are jobless, and obviously the indirect employment through sale of this tea to the outside world. From my point where I stand, the prices of food in this country, they are caused by regulations which hinder forces of supply and demand signaling prices. We did a study on removal of regulatory obstacles, and it's a study we are focusing on, which we did in the year of 2015-2016, so that we can be able to remove these regulatory obstacles and help the government achieve the Big Four agenda. I can see the authority, within 8 years, has seen its budget grow from 150 million to 658 million. That's good capital outlay within such a short time. Number 2 is that we have seen our numbers increase from when we came into place, from about 25 to the current number of 75, and we are progressing to 99. So in terms of resources, I can say that we are grounded and we are successful.